Hello, everybody. Hi, good friends of the good glory. Welcome to Children of Darkness and Light. This is our Friday night chat where we talk about all things Daybet Vallow Daybell. And so I'm glad you're all here. I'm just going to let the live stream catch up for a minute. Sorry, we started a minute or so late. I was chatting with one of my moderators and wasn't watching the clock. So my apologies. The other thing to know tonight is that my dog wrangler is off in Las Vegas watching the Las Vegas Bowl because the Oregon State Beavers are playing Florida, I think. And I don't have a dog wrangler tonight, so you may see them wandering around in the background. Hopefully, they will behave, and hopefully, it's late enough that we aren't getting any UPS deliveries that will set off the dog alarm. So, welcome everybody. You can see in the background, I've been doing a little bit of quilting. I've got a little project I'm working on for my daughter for Christmas. I'm hoping I'm going to get it done in time. And then once we get through the holidays, we're going to dig into the True Crime Quilt Guild. For those of you who haven't heard about it, I will post some information in the show notes so that you can get caught up. But we're going to start doing a sampler style block of the month, and I'll be putting out a couple of little instruction videos for those who are not quilters. So it is appropriate for beginners, and I hope that you'll all join us. And I just thought it would be a lot of fun to do while we wait for trial, which is going to happen on April 3rd. At least that's what they tell us. My goodness, I just caught in chat, hello, Winnie, who says good morning from Tokyo. So good morning, Winnie. Welcome to everybody who's here in our live chat. Please let your friends know that we're live if you've got friends that follow us. I know that Hidden True Crime started a little early tonight, so they have a few viewers that may be rolling over to us once they wrap up. And so hopefully we'll add some folks as time goes on. One of the things, there's not a whole lot going on in our Vallow Daybell trial, but there are many things still to talk about as we're thinking about the upcoming trial. So we do know that the court issued a notice of trial setting. Now, at the last hearing, the court said that he was going to put out a schedule. Whoa, that's right. I just pulled up the document on my other screen. The judge said that he was going to issue a scheduling order because he wanted to not only talk about pretrial scheduling, but also motion hearings. So I was a little surprised that he didn't set a firm motion deadline, but he did set a pretrial conference that is on February 27th of 2023 in preparation for the April 3rd trial date. Now, during the hearing that happened last week, he did say that he was interested in trying to start jury selection sometime in late March so that the trial could start promptly on April 3rd. A lot of that is going to depend on how the Ada County Court here in Boise can accommodate that. So I know that they will start, they're working on jury questionnaires. Jury questionnaires go out to jurors once their jury summons go out. They use, oftentimes they use DMV records, people who are licensed drivers, and they send out random subpoenas out for summons for people to come and serve on jury duty. Then they will call many more jurors than they would ever need. They might call several hundred people in order to get a jury. The first thing they will do is they will call that whole group together and they will say, does anybody here know about the Vallow Daybell case? Is anyone here related to one of the parties or one of the lawyers, or you know somebody who's directly involved in the case? And then if not, they will also ask, is there anybody here who's been closely following the social media and the media? And is there anybody here that's formed an opinion and feels that they couldn't be uh, unbiased when it comes to making a decision about the case? That usually weeds out quite a few people. I'm sure it will in this case because it's such a high visibility case. And then from there, they will ask the remaining people to fill out a jury questionnaire. The jury questionnaire is developed by the defense and the prosecution, and it is developed to begin to understand who their jury pool is and be able to formulate some ideas about where a person might find where they might find that a person has bias. So then once the jury questionnaires are completed, and that probably is the part that Judge Boyce would like to have done prior to the April 3rd uh, trial beginning, the substantive part of the trial beginning. Then those jury questionnaires are shared with both the defense and the prosecution, and they're able to go through them and mine them for information about jurors. Yes, hello, buddy. And then from there to decide whether there are any challenges for cause that would come out of those jury questionnaires. Once that process is done, then the process of voir dire begins. And voir dire is the Latin term for the questioning of the jury. This is Saber. He's my Labradoodle. He's a chocolate Labradoodle. And he has decided that since Dad is gone, he needs to come in and visit me. So once voir dire starts, then that is the point where the lawyers will be directly questioning the people who are in the jury box. And as they go along, they will question folks in the jury box, and then they will challenge um, jurors based on whether or not they think there is a challenge for cause. They also are filing away in their memory file jurors that maybe feel are not the best fit for their theory of the case. So once all of the challenges for cause have happened and both lawyers have had the opportunity to question the jury, then they will exercise their peremptory challenges. And each one gets a certain amount, not positive of the number here in Idaho. I can look it up. And then once that happens, each of the jurors, the lawyers have the opportunity to challenge jurors for, you can challenge as many jurors as necessary if it is for cause, if there is a reason why you think that juror couldn't be fair. But the juror lawyers also get a certain amount of, I don't have to have a reason, I just don't have a good feeling about this juror. Those are peremptory challenges. So once the jury is selected and both parties agree that they've exhausted all of their peremptory challenges and the jury is the jury. That jury then is sworn in by the court, and then the judge gives the jury some opening instructions. And those opening instructions are about how to listen to and evaluate the case while it's going on. And then once all of the evidence is heard, the judge will instruct the jury on the law, how it applies to the facts, and the process of deliberation. So I think Judge Boyce would like very much to have at least some, if not all, of the jury selection done before the trial starts in early April. That might be overly ambitious, depending upon whether or not Ada County can accommodate that, and whether or not they can get all the jury summons out and back beforehand. So, but at a minimum, we're planning for a trial that starts on April 3rd. For all of you who are not in the Boise area and are not going to stand in line and wait for the trial to start and wait for a seat in the trial, I am going to do that, and my plan is to be there every day, with the exception of a couple of days in May because I have a wedding coming up. So but we'll make sure that time that I may not be available is covered. The other thing we don't know for sure is whether or not Judge Boyce is going to change his mind about cameras in the courtroom. Um, I think that it is possible. I think there's about a 50-50 chance that he may change his mind about that. And the reason I say that is because when you move a proceeding from its home county to a different county, you foreclose the opportunity for the citizens of the county, where the prosecutor is the elected official, where the judge is an elected official, and the citizens of that county have a right to see what their government officials are doing. So when you move out of the county, you keep those people who might come and say, just want to see how the things are going here. They don't have the opportunity to do that. The judge has said that he wants to set aside seats for people who are from Fremont County, but what that's going to look like, it's hard to say. The other issue is one that I've brought up repeatedly and encouraged the family members of the Cox family, the Vallow family, the Daybell family to communicate to Judge Boyce, and that's what a hardship it is for them to be able to know and participate in the case when it's so far away and it's going to be a really prolonged trial. That, I think, could be persuasive for Judge Boyce, that people like the Vallow family who are down in Louisiana, it's not so easy for them to all come en masse and stay in Boise, Idaho for 3 months while this trial takes place. Likewise, the Daybell children, the Daybell family, nieces and nephews, Chad's siblings, they all have jobs that they aren't going to be able to just come to Boise for 3 months for a trial either. So, and I think that with the level of publicity, it makes it very difficult for them, even if they do want to come, to weather the publicity scrum that they have to go through every day to try and get into the courthouse. So I'm hopeful that Judge Boyce is going to reconsider that. If he doesn't, I'm going to be in the courtroom. We'll be doing YouTube shorts at the lunch break and then afterwards, and then we'll be doing a full-on recap, probably on Saturdays. So if you are at all interested in that sort of information, please be sure you're subscribed, because as the trial gets closer and more things happen, we're going to be going live whenever something develops, and we're not going to be just going live at the times that we usually do. So for those of you who might be new to the channel, True Crime Wednesday is our Wednesday show, 6 p.m. Pacific, where we talk about other cases other than Vallow Daybell. On Friday nights, we're just devoted to Vallow Daybell. But on True Crime Wednesday, we talk about other cases as well. So I had a follower who asked me if I would talk about proof beyond a reasonable doubt. So I'm going to give everybody, because we have a few minutes yet before we're going to be ready to take some questions, I'm going to talk a little bit about reasonable doubt and about legal burdens of proof. So in the law, we have different burdens of proof for different kinds of cases. So in a civil case, you have to have a preponderance of the evidence. In numerical terms, that sort of relates to about 51%. More likely than not, that the thing that plaintiff alleges happened. So it is a much lower standard. This is the reason why, after O.J. Simpson was acquitted, was found not guilty, his victims' families sued him in civil court for wrongful death because the burden of proof was much lower, and they were able to get money judgments against him for wrongful death, even though the prosecution didn't prove beyond a reasonable doubt that he caused the deaths of Nicole and Ron, because the burden of proof was much lower in the civil case. So they could prove by a preponderance of the evidence that it was likely that he was the perpetrator, but the criminal case couldn't get to beyond a reasonable doubt. So in a civil case, we're only talking about a preponderance of the evidence. There is an interim step which applies to a handful of types of cases. One of them is restraining order cases, and they have to be proven by clear and convincing evidence. And numerically, that relates to about 75%. But I'm 75% sure that the evidence proves what the plaintiff has alleged. There aren't a lot of places where evidence has to be proved by clear and convincing, but there are a few places in the law that applies. And then, of course, we have criminal evidence that a criminal charge has to be proven beyond a reasonable doubt. And that is usually quantified as somewhere around 97 to 99% sure. So we assume that a thinking person, a reasonable thinking person, is always going to allow for there to be a little bit of doubt, and that we all sort of live with a little bit of doubt, and that's normal. So we never say you have to be 100% certain. We say there's room for a reasonable doubt. So in this case, we would say beyond a reasonable doubt, 97 to 99% sure that Lori Vallow and Chad Daybell conspired to murder JJ, Tylee, and Tammy. So that sort of gives you a little thumbnail about what it is, what reasonable doubt is, and how it applies in the law. Going forward, it's going to be interesting because to apply that, you have to develop a theory of the case. And the theory of the case that the prosecution has may vary very different, likely will vary widely from what the theory of the defense case is. More interesting is that I think the theory of the case is going to vary pretty vastly between the two co-defendants as well. So we have Lori Vallow saying, here was this guy who it was sort of a Svengali. He played into all of my mental health issues, to all of my delusional issues. He convinced me that he was a prophet, that he knew that we'd been married before in previous life. He validated all of those things that I thought about my faith. He validated all those things I thought about myself, and all of the things that I'd been reading, and all of these kind of offbeat LDS books like John Pontius's Visions of Glory and all of those books. And now he's the one who convinced me that what we were doing was right, that what we were doing was justified because we're part of the 144,000, and it's really all on him. He was the mastermind. On the other hand, we have Chad saying, Oh, no, no, Lori was the mastermind. I was just the guy who was taken in by the beautiful blonde who had a romantic interest in me. So, I think those are gonna be really, really opposing theories of the case, and I think, it's going to be interesting to see how they present, that theory to against one another. Um, so we know that Lori's competent. We know that she's had a recent evaluation and that the court has found her competent to go forward. We know that we heard from at the last hearing, there was a motion about discovery. And that motion had to do with whether or not there was a the motion had to do with whether or not there were FBI reports that had not been turned over to the defense by the prosecution. And the issue was initially, Rob Wood said, "Oh, well, the FBI did them. We don't have to turn them over because they're not a state agency," which is absurd. And he then later walked that back and said, "Oh, no, no, but we were just doing trial preparation and we were talking to witnesses and they didn't say anything new," which sort of begs the question of why the FBI re-interviewed them if they didn't say anything different from their previous interviews. So, um, specifically, the defense was looking for information from Zulema Pastenis, from Melanie Gibb, and from Melanie Pulowski, formerly Boudreaux. So Melanie Pulowski is Melanice, that is Lori's niece, and then Melanie Gibb was her good friend. We suspect that all three of them, I suspect, I should say the royal we, I suspect that all three of them have immunity deals. And there's a couple of reasons why I say that. We know that Zulema has an immunity deal because it came out in an interview that was recorded that Rob Wood had with Lori's sister, Summer Shiflett, and Zulema. He went to Arizona, had a meeting with them, and that's pretty typical when you have somebody who you're offering immunity to. Now, the one thing is that Zulema is in Arizona, and but Rob Wood enlisted the assistance of the Arizona authorities and the Arizona prosecutor to extend immunity deal to at least to Zulema. The reason I think that both Melanies have deals as well is this. When Mark Means was still on the case, he served a discovery demand on Melanie Gibb. It he had no authority to do it, and it was kind of meaningless. But he served it on her when she was coming out of testifying before the grand jury. And her first comment when the process server handed it to her was, "Call Rob Wood," which to me says what she was saying was, "Oh, no, no, this is not part of our deal. You call Rob Wood. I'm not saying anything to anybody unless it's approved by him." Um, the reason that she's saying that is because she doesn't want to do anything that's going to run afoul of her agreement. The other one is Melanie Pulowski, the niece. And you might remember maybe 3 months ago, may have been a little longer. She was charged with identity theft. And the identity theft had to do with her accessing her ex-husband, Brandon Boudreaux's bank account after she was supposed to have gotten off that account according to their divorce agreement. So she then the state in Arizona filed charges against her, and those charges lasted about 3 days or so, and then they were dismissed. That's a pretty good indication that they filed those charges to get some leverage on her because they felt like she wasn't cooperating enough, and they got some leverage on her and decided that they would only refile that if she doesn't cooperate and doesn't live up to her agreement. So I think those three have some sort of immunity agreements. Um, I also had a question from somebody who asked me whether I thought the same thing had happened with Colby, and I don't think that at all. In fact, my experience, both as a prosecutor and a defense attorney, would say just the opposite. Probably what happened was Colby's a young guy. He's under a lot of pressure. He doesn't have a criminal record. When the prosecutor started looking into the case, talked to his attorney, and understood what the circumstances were. It was a domestic dispute that arose out of their his separation from his wife. And I think probably the prosecutor said to Colby, listen, I don't want to be the guy who blemishes your record. So here's my deal. You go get help. You go get counseling and treatment for your mental health issues. And if you follow through with those the way you say you will, I'll dismiss those charges and I won't refile them. And I think that's probably what happened with Colby. Um, a very different situation because I don't believe that Colby ever had any um, knowledge ahead of time about what was going on with Lori. No question, he knew that she was acting strangely. He knew that she had a history of making strange comments, and it was clear that she was deep into this doomsday stuff. But I still don't think that he had any knowledge ahead of time about what Lori was planning to do. So those are some of my thoughts. I think we're going to see some more motions. There were motions that did not get heard last week, and that they all agreed that they were going to schedule for what defense lawyers usually call an omnibus hearing. An omnibus hearing is one where we hear all the motions and we deal with all of the issues coming up pre-trial. So one of the things that happened was that Jim Archibald has filed a couple of motions that are challenges, more legal and philosophical challenges to the death penalty. And those motions were on for hearing, and the John Pryor communicated to the judge that he intended to file similar or identical motions. And the judge said, well, maybe we should just delay hearing those until those motions are filed. We can hear the same issue all at the same time. So those motions are going to be coming up. As I've said before, these are very typical motions that people put in play, that lawyers put in place because they're hoping that at some point one of those motions is going to work through the pipeline to the US Supreme Court. So those are ongoing issues. I do want to say a little something about the death penalty and something that happened today, and then we'll get to questions. So last comment, and then y'all can be thinking about posting your questions, and our moderators can be going back and looking for questions. Governor Kate Brown, who is the Democrat governor from the state of Oregon, she is coming to the end of her second term, and she just commuted all of the death penalty, all of the death sentences in Oregon to life in prison without parole. She did that, and we've talked a bit. I know we talked on Wednesday about some of the issues that are coming up with the death penalty. The most serious issue coming up, and it came up here in Idaho about 2 weeks ago. A man who has been on death row in Idaho since 1986. He was convicted in 1986, and his case has been winding its way through the appeals process. Well, he finally exhausted all of his appeals, and the state of Idaho issued a death warrant and gave him an execution date. And then the state of Idaho only allows execution by lethal injection. And a lot of states have gone that way. There isn't an alternative method. And the state of Idaho went out on contract to get the drugs that are necessary to administer a lethal injection. and the manufacturers who are manufacturing those drugs are refusing to sell to states for the purpose of lethal injection. It's a conscientious objector kind of a situation where these companies are saying, we don't believe in the death penalty, and we don't believe that our drugs that we produce for a therapeutic reason should be used to end someone's life. We've known for a long time that that what we've known for a long time that doctors and nurses have declined to administer lethal injections because they feel it violates their Hippocratic oath. And so there have been lots of problems when you get somebody who is trying to start an IV who isn't an expert at it. And then, of course, there have been several botched executions because of states trying to use alternative substances, alternative drugs, because they can't get the actual formula for the drugs that go into a lethal injection. So it's been very problematic, and a lot of state governors have been hesitant. The state of Oregon, the Oregon governor, prior to Kate Brown, instituted a moratorium on executions about 10 years ago, and that moratorium's been in place since then. And that was, again, because of all the problems with the death penalty. So people have varying opinions about the death penalty, and I generally try not to express my own, because that's not necessarily what people want to hear. They want to hear the facts and make up their own mind. I think that we as a society have kind of moved away from the idea that the death penalty is effective. We know that it is not particularly a deterrent. We know that it is exceedingly expensive, and that for the cost of one death penalty prosecution, you could keep somebody in prison for life without parole. You could keep many prisoners in prison with life without parole for the cost of one death penalty case. I think more and more the public and governments are realizing that it isn't necessarily the best use of our resources. And I think that in general, there is sort of a societal move away from it. A lot of other countries other than the US have banned the death penalty. And I think that as a society, I think we're moving away from it. I think we're going to see fewer and fewer death penalty prosecutions, and I think we're going to see fewer and fewer death penalty convictions. As I say, executions in some places have been on hold for years now. So, um, that it is a decision that is left up to the state government and the voters of those states. And so, I mean, my perception is, over the years that I have been practicing criminal law, I think we have seen a diminishing of death penalty, emphasis on death penalty and death penalty cases. Um, we saw a real drop in death penalty cases. Then the Supreme Court um, outlawed the death penalty because it didn't meet certain criteria. Then a lot of the states their voters began voting the death penalty back in set up in a way that met the Supreme Court's requirements, mostly that you have a penalty phase, and then you have a guilt or innocence phase, and then you have a penalty phase where the defendant is able to present mitigating circumstances. So at the hearing that we had last week, John Thomas talked a bit about the discovery issues that they're having. And when prosecutor Rob Wood got up and sort of very carefully parsed his words about how nobody had said anything new in any of those interviews, John Thomas called his investigator, their investigator, up to talk about it. He was caught off guard by Rob Wood, really, in his opinion, out and out lying, and called his investigator. He really wasn't prepared to think through how to get this information in, but clearly the investigator had been working on the case. He did say he went to Arizona to see Zulema and was told that she and her attorney were in Rexburg. And when they inquired about why she was in Rexburg, she was being re-interviewed by the FBI. So they said, "We want those reports." And Rob Wood's like, "Oh, well, she didn't say anything new." The point is that Rob Wood doesn't get to decide that. He has an absolute obligation to provide everything, regardless of whether it says anything new or not. So Rob Wood's playing kind of fast and loose with the rules of discovery, and I think that's problematic. Um, and I don't know why. I don't know why he is claiming that everything that happens in his office is attorney work product, which is not true. He is claiming that he does not have to turn over discovery, and the truth of the matter is, it could end up biting him, because it could end up that these cases get overturned because he's ambushing them. John Pryor mentioned in court that that morning when he came into the courthouse, Rob Wood gave him a thumb drive, and the index showed it had 115 items on it, and that was all new discovery. That's outrageous. If it were me, John Pryor was way more restrained than I would have been, because that's just sandbagging. There's no way for the defense to go through all those things and try and figure out what's on that, and go back and re-interview people. And I mean, it is really giving them discovery at the ninth hour. So, but interestingly enough, the investigator was there, and so now we know who he is, and his name is Brandon Hobbs. Um, he is based out of Arizona, which is a little odd, and he has recently been both in Arizona and in Louisiana, which I find a little interesting. Um, Whether he was working on this case or not, I don't know, but he definitely was in Louisiana recently. He is also working with a mitigation specialist. Let me look her name up because I've forgotten it. Mary Goody. Should remember that. And she is a mitigation specialist. So we do know that there is at least one investigator and a mitigation specialist working on the case with Archibald. As far as we know, John Pryor's staff is still limited. So let's take some questions. Anybody have questions for me? Lee here. Their argument was good on this one. Do they have to disclose if nothing new is said? Yes, because it's not up to the defense or the prosecution to decide nothing new was said. It's up to the defense to decide that. So the prosecution literally has to turn over everything. The way it's analyzed for its value is up to the defense. But it absolutely has to be turned over. So their argument that somehow that it was information that they did while they were having interviews with witnesses for trial preparation, and that's covered by attorney-client privilege, is just BS. It's not. So but unfortunately, the judge did his usual waffling and said what they were arguing about was what the statute meant when they said reports, and so they were arguing over the meaning of the words in the statute. And the judge's answer was, well, I will compel discovery to the extent that it's required under the statute, but it's up to the judge to interpret what's required under the statute. And at the last minute, he punted. So it was a little bit of an empty victory, I think, for poor John Thomas. Good question, Kathleen. I don't know. I suspect that he may not sequester them until the case goes to them, and then sequester them for their deliberation. Um, if he allows cameras, jurors, a lot of direction is a little bit on the honor system. I mean, jurors are directed, don't talk about the case with anybody. Don't talk about among yourselves about the case until it's time to deliberate. Don't share your notes. Don't watch the TV coverage. And they're on their honor to do that. In cases where jurors have not followed the judge's directions, they have been held in contempt. You might recall in the Lacey Peterson case, there was a juror um, who did some outside research about a boat or something, and that juror was sanctioned for that. So I think the judge can direct and instruct the jury in a way that lets the jurors know how very serious this is and how big their responsibility is. And so most jurors want to do a good job and are likely to follow the judge's instructions. Once the jury starts to deliberate, then I think perhaps the judge might sequester the jury during deliberations, just because and probably more so because there will be less distraction with all the media. So, because jurors are going to end up being um, assailed by the media. Hi, Catlink. Do you think prosecution is overconfident and that's why they've been sloppy on sharing discovery? I felt Rachel Smith's condescension was out of line, and were I a juror, it would turn me off. Yeah, I think I don't think they're overconfident. I think they're overly arrogant. And I think there's a difference because I frankly don't think that they have reason to be overconfident. I think that it's a good idea to be sure that you have a strong case, that you can prove beyond a reasonable doubt, and that you're confident about your case. But I don't see them, a prosecutor who is confident about their case says, sure, have it all. I want you to have all that information because I want you to understand how overwhelming our evidence is. And I don't see that here. I see that there's a lot of hubris, and that's concerning. There's a lot of I'm a big fish in a small pond, and there's a reckoning coming for that because I think they're going to find out how very small fish they are when they really take on this case. It's very concerning. I think it's concerning to everybody that these are not professional prosecutors. They are small town prosecutors who are used to prosecuting DUIs and domestic violence cases and the occasional theft from Walmart. They are not prosecutors who are accustomed to trying complex scientific cases. And I that's been concerning to me from the very beginning, particularly when the Fremont County prosecutor before Lindsay Blake, Marsha Murdoch, said, I'm not equipped and my county's not equipped to handle the Tammy Daybell case, because at that point, that was the investigation that was happening in Fremont County. This was before the children's bodies were found. And she referred the case over to the state attorney general, which is what rural jurisdictions often do if they find that they've got a case that exceeds their resources. And it wasn't until Lindsay Blake was elected that she asked the state for Tammy's case back. And then the kids' bodies were found, and then they filed the charges all together in one indictment. So I think there's a tremendous amount of hubris here. I think there's a tremendous amount of ego. I think they think these are career-making cases, and they may very well be. But we can't forget the Jodi Arias case and the fact that uh, prosecutor Juan Martinez ended up getting disbarred because of his behavior during the Jodi Arias case. In fact, both lawyers got disbarred. So, I mean, taking on a case like this is it's like a double-edged sword. So, the other thing I think is oh, lost my train of thought. So we'll go on to the next question. As they crossed state lines while the conspiracy was in play, why isn't it a federal case? Because of the 14th Amendment to the Constitution. States have prosecutorial um, uh, precedents. So, in a case that is a violation of a state statute, they take precedence in prosecuting. So, in this case, yes, they did cross state lines during the prosecution, but in general, federal prosecutions are kept uh, are only brought in cases where federal statutes are violated. And so it wouldn't be a federal prosecution because they cross state lines. Because it would still be a violation of Idaho law rather than of a federal statute. So there was some discussion about whether or not she would be prosecuted federally for the Social Security misappropriation, and that could still happen. I think that's one of those things they're just kind of holding off and to see whether or not it's necessary. So, often prosecutors, and I'm sure the federal prosecutors are working along with the prosecutors in Arizona and in Idaho. They're all talking to one another. And, they have kind of prioritized the prosecution. So Idaho's going to go first, then it'll be Arizona, and then, if necessary, federal charges. That way, it's like belt and suspenders. If for some reason the Idaho charges were to fail, they've still got backups. These folks aren't going to walk because there's still charges in both Arizona and then potential federal charges too. So, girl drink drunk. I wonder if either of them have cellmates. Well, we know because there was a woman who was interviewed at one point. Um, we know that Lori, I don't know whether she had a cellmate or whether she was just in the cell next to another woman in a separate pod. Um, Often, the way that jails are configured is they will have several cells, and then in the middle they will have a common area that where inmates are allowed to gather in their spare time, and that's called a pod. And at one point, she was housed in a pod that was not occupied by other inmates, and then they had overflow and they moved this other woman in with her. I suspect that they are trying to keep her as separate as possible from the other inmates. Um, Often you will find that in a jail situation, they will separate out people who have not yet been tried and sentenced from people who are serving low level misdemeanor kinds of sentences, because that's how you get to jail. Either you're pretrial or you have committed a misdemeanor that's punishable by less than a year in jail. If it's more than a year, then you go to prison. So as far as Chad goes, I suspect he probably does have a cellmate. The men's accommodations or the prison accommodations in Fremont County are tiny. I mean, tiny. And I would be very surprised if they had enough cell space so that Chad wouldn't have a cellmate. Ladybug Lady. I have some concerns about the potential for dismissal, particularly as it applies to Lori Vallow Daybell's speedy trial rights. That's concerning. Jim Archibald has already said that he plans to file a motion to dismiss based on her lack of speedy trial. Although he did put on the record that he believes that because of the extensions the judge did early on for good cause, that Lori's speedy trial runs the 21st of February. So 21st of February until April 8th is a matter of a week because February is a short month. So I think, no, a week and a month. Sorry, forgot March in there. I think it's possible that the judge may say, because we had to change venue, because we had to have a continuance, because we have to be accommodated by Ada County, that good cause exists to extend it to April. Whether the Idaho Supreme Court buys that or not is a different question, but I don't think that the case will end up in dismissal pre-trial. It is possible that the Idaho Supreme Court could say you overstepped her speedy trial rights, and so the case would need to be dismissed. Whether the case gets dismissed with or without prejudice is would depend on the Idaho Supreme Court. So I find the prosecution's behavior very concerning. I think that the prosecutors are feeling like whatever happens, they can take it up on appeal. We're going to do it our way, and they can take it up on appeal. One point I did want to make, that was the thought that went out of my head and has now come back, is the issue of ineffective assistance of counsel, because we, just like these prosecution behavior, we also have some concerns about the fact that John Pryor is a sole practitioner and perhaps doesn't have the kind of appropriate support for a death penalty case that he should, and whether or not that would amount to ineffective assistance of counsel. So people express concerns about that often, but in fact, it is a very high bar to get something overturned for ineffective assistance of counsel, because the first question is always, did it matter, or was there sufficient evidence to convict that person over was the evidence overwhelming enough that the person would have been convicted anyway? And that's a pretty high bar to reach, to say, if I'd had a better lawyer, the evidence would have been different and I would have been acquitted. That's very rare. In general, what a court would say is the fact that your attorney maybe didn't object to hearsay when they could have, or they didn't object to this piece of evidence coming in, doesn't change the fact that the evidence against you was so overwhelming that you would have been convicted no matter what. I mean, even if you'd had F. Lee Bailey. So it is difficult to have a case overturned for ineffective assistance of counsel. There's a very famous case from the South where the defense attorney literally slept through most of the trial. And the court still said, it's not ineffective assistance of counsel because the evidence against the defendant was so overwhelming that no, even if their attorney had objected to every single question, it wouldn't have changed the outcome. So it's always a question of whether if you had had different counsel, it would have changed the outcome. So I think that's what John Pryor's hanging his hat on. Brennan Tube. You guys have such interesting usernames. Mine's boring. It's my name. I have a question for Lori. Does she think there is a chance the charges could be dismissed because Lori's speedy trial rights were violated? You know, I don't think that I don't think that Judge Boyce will dismiss her case because her speedy trial rights were violated. I think he is going to do whatever legal gymnastics he needs to do to justify exceeding her speedy trial rights, say that there was good cause for it, and go forward with the trial. Whether what the Idaho Supreme Court does with that could be a completely different kettle of fish. They could say the charges should have been dismissed. They could say she should get a new trial. That could be very well be up to the Idaho Supreme Court. I have looked at the cases that the Idaho Supreme Court, the speedy trial cases that are out there, and they're not super informative about, in some states, the courts have just come out and said, if you exceed speedy trial by a month, it's okay, but if it's 6 months, it's not okay, and sort of given some parameters. That's the Idaho case law isn't that helpful on that issue. So I think it's unlikely that Judge Boyce will dismiss the case pre-trial based on the speedy trial issues. It's possible that the Idaho Supreme Court could see it differently. Hi, Mary. Perhaps I have formed an early opinion, but my fear is that Lori and Chad may get off because of the arrogance of the prosecution. What happens then? You know, I'm not so concerned about that. I'm concerned about the fact that the prosecution is not being straightforward, which I think is their job. And I think that my concern is that the prosecution may, out of their arrogance, say, we don't have to do that, or you don't get that. And then it ends up being an appellate issue. So I'm concerned that the prosecution is causing more appellate issues than they really need to. Because a good professional prosecutor is going to say, here, have everything. Because I have enough confidence in my case that I'm going to give you everything and you decide whether or not you want to defend your client and how you want to do it. I think it's more likely that the Idaho Supreme Court is going to be reviewing and reviewing and reviewing this ad nauseum. I think it's more likely that that they're going to spend millions of dollars on post-conviction motions. Do I feel the death penalty is a big bargaining chip? Well, I don't think anyone wants to be convicted of the death penalty because then you do have the even remote possibility at some point that the state could execute you. On the other hand, with what's going on in the country in general having to do with the death penalty, I think it's less of a bargaining chip than it used to be. Back in the day when a lot of states were quite readily and some might say aggressively executing death penalty defendants, I think it was a bigger bargaining chip. But you look at the history of the last person who was executed in any given state, and you're going to discover that it's that it is not being applied. People are not being executed like they were, not even 10 years ago. So I think it's less of a bargaining chip than it used to be, particularly when you're looking at in the state of Idaho, the most recent guy to get a death warrant has been on death row since 1986, and so and he's been receiving hospice treatment for liver cancer, I think it is, or some sort of cancer for 3 years now. So he's likely to die in custody before he's ever executed. Hi, Debbie. Question: could Chad claim he is indigent at this point in time and derail the trial? I think it's possible, but we have not. Uh, uh, Anything is possible. Chad could say, "I don't have any more money to pay my lawyer. I don't have any money to pay experts, and I don't have any money to pay investigators and mitigators, and so I need the help of the state." And he could do that right up until the day of trial. And yes, it could derail things if John Pryor were to step back and say, "I can't represent him anymore." But that does not appear to be what's going on. When John Pryor filed his motion to continue the case and asked for more time and went through all the reasons why, because he was a sole practitioner and needed more time and blah blah blah, I thought that it was possible that was a signal that he was going to be withdrawing and asking the state to appoint a or a defense attorney for him, a team. But it hasn't happened. And the further away we get from that, the less likely I see it happening. And certainly when we had the last hearing last week, John Pryor was still there arguing full throatedly for more time for Chad, for more, and still saying we need more time, we need investigator, we blah blah blah. But he didn't say I can't provide adequate counsel I'm because we don't have any money. So the further away we get from that, the less likely it looks that he's going to withdraw. It's possible that it could be a last minute tactic, but allowing an attorney to withdraw is discretionary with the court, and the judge could say, "I'm sorry, Mr. Pryor, we're too close to trial. You are going to try this case." Um, so withdrawing on the eve of trial is never smart, because it's more than likely that the judge is going to say, "Too late." So, couple things to remember. Oh, take this question from Sabrina, and then I think we'll wrap up. We're right at the 1 hour mark. I like to try and stay right in that sweet spot. Do you think we'll be surprised by any evidence presented at trial, given everything we've already seen and heard? Yeah, I think we're going to see a lot that we don't know. The reason I say that is because I've heard that from people close to the case. I have heard from law enforcement. I have heard from people close to the case. You think it's a shocking case and that there's a lot now. Just wait until trial. So I think we're going to see some evidence that we haven't seen. Um, Remember that Idaho and Arizona's Freedom of Information Acts are different, and in Idaho, you can't get Freedom of Information documents until post conviction. So in Arizona, they don't have an exception for pretrial disclosure, which is why we got those big data dumps ahead of a trial. But we've only seen the Arizona stuff. So the Idaho stuff, they have a legal exception to releasing anything before the trial. So I want to remind everybody that there won't be any True Crime Wednesday and no TGIF next week because it's Christmas. And I'm going to be celebrating with my family. I hope you are all as well. I also want to remind everybody that the Justice for Tylee and JJ wristbands are available. All you need to do is send me a self-addressed stamped envelope. And if you happen to be overseas, you can still request one. Send me a self-addressed envelope with the appropriate amount of postage for 1 ounce. These go for one stamp is all it takes. Um, and we'll make sure that you get them. Right now, I have 2 requests that I haven't fulfilled that I will get in the mail here shortly, but we're pretty up to date. So do request them. My hope is that by the time the trial gets here, we are going to flood social media with pictures of folks wearing their wristbands, because I think that would be an appropriate tribute to Tylee and JJ and to Tammy as well. So join us the week after Christmas. The week after Christmas, we're going to be talking about some of the new things coming up next year. Please do like and subscribe and hit the bell. I forget often to ask you to do that. I know my mods put it in chat all the time, but please do that. It helps us with the algorithm, helps us move up a little bit. I also want to remind everybody the tickers at the bottom, all of your super chats, any donations that you make to super chat or to PayPal go directly to our moderators because they deserve it and I couldn't do it without them. So everybody have a Merry Christmas. We'll reconvene right after the thank you, Paula, you too, Kiki. Merry Christmas to everybody. And then we'll reconvene the week after Christmas. And early in January, we're going to start our quilt block of the month. And I'll be getting some more information out about that. Rest assured that if you are a beginning quilter, you are in good company. There are lots of folks who are going to be making their first quilt. I'm going to be putting out some instruction videos to make sure everybody's up to speed. And then we'll have a time when we can share our blocks and everybody can participate. So please look forward to that. Have a really Merry Christmas. Be safe out there. It's cold and it's icy in an awful lot of places, including Boise, Idaho. Drive safely if you're going to be on the road visiting family. Take care, you all, and I'll see you back in a week or so. Good night.